Get ready for the dictation. On the count of 3, 2, 1, start. This appeal under Section 37 of the Arbitration and Conciliation Act 1996, hereinafter referred to as the 1996 Act for setting aside a unanimous award dated 12/3/2013, passed by the Arbitral Tribunal, partly allowing the claims of the respondent Progressive Constructions Limited. The appellant entered into a contract dated 12/8/1999 with the respondent, whereby the appellant awarded to the respondent the contract work of 4-laning a section of National Highway number 31 at the Punia-Gaya Kota section. The contract in question was a unit rate contract, and the bid documents contained a detailed document referred to as Bill of Quantities, which enumerated each item of work with the estimated quantities to be executed by the respondent. The respondent filled in rates against each item. The appellant has pleaded that the tender conditions specifically provided that the bidder would have to satisfy itself regarding the site condition, and no claim was to be entertained on the plea that the information supplied by the employer, National Highway Authorities of India (NHAI) was erroneous or insufficient. According to the appellant, the purpose of such a condition was that a bidder would be able to incorporate all possible costs of work item-wise in its financial bid, taking into account the conditions prevailing at the site, so that the appellant was not unduly saddled with any claim in the future on the ground that such costs were not foreseeable by the contractor. According to the appellant, the other purpose of requiring the bidder to fully acquaint itself with the geographical, climatic, soil, and other conditions at the site of the construction was that it would be incumbent for the bidder to make a reasonable assessment of the costs which would be incurred by him in execution of the work by considering all relevant factors, and the bidders would have to make honest and real assessment of the expenses likely to be incurred by it while calculating its financial bid. According to the appellant, the object behind incorporating such a clause was to eschew practice amongst bidder of quoting lower bid to procure the contract and later raising its claims on account of an additional works by the guise and subterfuge of underbid. The bidder manages to procure the work by deliberately underquoting, but eventually the purchaser ends up paying much more. The appellant contends that the respondent raised claims which were nothing but an afterthought, and none of the claims were justified at all, since everything had been accounted for in the item-wise rates quoted by the respondent itself. Disputes arose between the parties with regard to execution of the contract. The respondent referred claims to the dispute review expert (DRE) for decision. The parties also agreed to extend the time for the DRE to give its decision. In the meanwhile, the respondent invoked the arbitration clause numbers 25.2 and 25.3 of the conditions of contract vide its letter dated 19/3/2007 and the appellant issued after dated 7/5/2007. The parties also agreed to extend the time of the DRE to give its decision, since no decision had been given within the time stipulated in clause 25.1. An arbitral tribunal consisting of 3 members was constituted on 21/6/2007 to adjudicate the disputes between the two parties. The respondent made 7 claims before the arbitral tribunal, which are as follows. Claim number 1. Cost compensation for increased cost borne for use of Parker stone in structural concrete and bituminous work in place of crashed coarse aggregate obtained from the river Rakti near Paina Kumari as source chosen by the claimant for rupees 7,38,09,000, which was subsequently modified to rupees 4,98,34,000, including escalation of cost. Claim number 2. Cost compensation for well point system of dewatering required to be undertaken for laying foundation of 4 number bridges below the foundation of the existing ones, amounting to rupees 60,61,221. Claim number 3. Cost compensation for excessive cost of embankment and subgrade construction owing to adverse soil condition in borrow area and site for amounting to rupees 61,94,000, subsequently modified to rupees 72,84,000 in the rejoinder. Claim number 4. Cost compensation for premature recovery of mobilization and machinery advance for rupees 20.71 lakhs, subsequently modified to rupees 16,27,000 in the rejoinder. Claim number 5. Cost compensation for idling of resources for rupees 880.50 lakhs, finally modified to rupees 8,30,64,000 in CH30, submitted on 2/9/2011. Claim number 6. Past interest on the amount held up at 12.12% per annum, amounting to rupees 8,12,11,349, pendent like light interest on the amount withheld at 18% per annum from the date of reference of the dispute to the arbitration till date of award, and future interest from the date of award till payment of the total awarded, amounting at 18% per annum. Claim number 7. Cost of arbitration for rupees 10 lakhs.